Good afternoon and welcome to the Society for the Rule of Law's webinar on birthright citizenship. My name is Gregg Nunziata, and I'm the Executive Director of the Society for the Rule of Law, and I thank all of you for joining us here today. Just a few brief comments of introduction. If you're not familiar with us, the Society is an organization, a national membership organization of conservative, libertarian, and center-right lawyers and others who share our principles and who are committed to the defense and uh, of the rule of law, the Constitution, and American democracy above partisan or policy preferences. To fulfill our mission, we have lots of events like this where we talk about interesting challenges of the day that have a significant impact on the rule of law and American democracy. Uh, if you enjoy this programming, I would encourage you to become a member. Our members make this programming possible. We have membership at various levels for lawyers and non-lawyers, students as well. Please, we'll drop a link in the chat where you can go and consider joining the society. Our next event will be in person. We will have a panel at the Principles First Summit here in Washington, D.C. on February 22nd and 23rd. The tickets are sold out, but you can still join the wait list, and the video will be posted on our YouTube channel after the event. Our panelists will be George Conway, Barbara Comstock, and Judge Michael Ludig, who are all members of the Society for the Rule of Law's board. After our program today, we'll leave ample time for questions. So I'd invite you to think about any questions you might have. Just drop them in the chat, and I will present them to our panelists as we go. You don't need to wait till the end. Please just feel free to start typing when things occur to you, and I will get to them whenever I can. So thank you all in the audience for being with us today, and thank our panelists, who I'd like to introduce now. We have Robert VerBruggen, who is a fellow at the Manhattan Institute. He writes on a wide array of issues, including economic policy, education, and public safety. We're also joined by Professor Ilya Somin, a charter member of the Society for the Rule of Law, who is a professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. He is the author of many books, most recently Free to Move, Foot Voting, Migration, and Political Freedom. Thank you both for joining me for this conversation today. I'm really looking forward to it. Before we get on, I apologize to you all that I'm losing my voice a bit, so I hope you can both bear with me and the audience can as well. And with that, I'd like to invite Robert to give us his opening thoughts on birthright citizenship. What is it? Are we blessed with it, cursed by it, stuck with it? What do we make of this crossroads threat?
Oh, well, thanks so much for having me. So all the way back in 2018, when this was an issue under the previous Trump administration, I wrote an article for National Review diving into this issue a little bit. And the title of that article, I think, really captures my view well, and it was called "Birthright Citizenship: A Nutty Policy We're Probably Stuck With." That's still my view. I'm not a big fan of giving automatic citizenship as a constitutional right to everybody who's born here, even if they're born here illegally. But I still think it's very difficult to argue against that as a legal matter. So as for the nutty part of that, why do I think it's nutty? I spent some time thinking about this so I could impress all the lawyers in the audience.
I think he's muted.
Was I muted that whole time?
Just the last 10 or 20 seconds.
Oh, okay.
Just after you said you were going to impress lawyers in the audience is when we lost you.
Okay. Yeah, no. So I was trying to come up with some really thoughtful and public intellectual kind of argument here. But honestly, my view on this is just not that sophisticated. I think it's a basic feature of the modern world. We're divided up into countries. We get to decide who comes in. We have borders. I think that's why that developed is rooted in human nature. We form communities. We fight over territories. We tend to kill each other over minor differences. And having the world kind of divided up this way and having some authority to decide who comes into your country is just a good system to have. And I think importantly, you can debate the level of immigration. I realize there's some libertarians out there in the audience, and Ilya is here on the call, who might want those limitations to be very, very little. And I think you can also debate when we find ourselves in the situation that we're in now, how to handle it, because we have a pretty large illegal population. I think we could debate who to naturalize via statute, because you don't want a large population of people who have been here 10, 20, 30 years and have no other country to call home because they were born here, who we don't consider citizens. I think those are all entirely legitimate discussions to have. But I think if we're going to have limits on immigration, if we're going to say this is our country and we have these laws, you're not allowed to come in here unless you satisfy this process and go through this process, I think it's really insane to reward people who sneak in illegally and have a child here with this extremely valuable gift that so many people go through with so much to get, which is U.S. citizenship. I think that just fundamentally doesn't make sense, and it's kind of a crazy thing to do. But as a right winger, as somebody who believes in the rule of law, I also really care what the Constitution says. If the Constitution lays out a policy that I think is wrong, I may want to change it. There are mechanisms for amending the Constitution, but we have to follow it. We can't just cast it aside because it is the law. I think that if you traveled back in time and talked to the drafters of the First Amendment and explained our current situation, they might well agree with me that it's kind of crazy to do what we're doing. But unfortunately, this was just not on anybody's minds back at the time that we enacted the 14th Amendment. What was at issue at that point in time was just after the Civil War. It was after the Dred Scott decision. And what we wanted to do is we wanted to make sure that former slaves and their descendants would be considered citizens, and we wanted to exclude from citizenship certain populations of people who we didn't think that should be citizens. And we did this in two ways. The first was the 1866 Civil Rights Act, which had very similar language to the 14th Amendment. The language of the 1866 Civil Rights Act is all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens. The language of the 14th Amendment is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So these slightly different language. We generally agree at the time that they meant roughly the same thing, but they were kind of tweaking it to make sure that they really precisely targeted who would be citizens and who would not. And when it created this debate where it's not precise enough and we're not really sure who should be citizens. So the key debate here is over those words subject to the jurisdiction versus in the 1866 Act not being subject to a foreign power. There is a limited reading in which this is is sort of a scalpel that carves out certain very limited populations, where it just means that the laws apply to you. Basically, if you can be arrested and tried in a court here, you're subject to our jurisdiction. And the broader exclusion would mean that this refers to something deeper, a type of undivided allegiance to the country of the United States. And I wanted to go through three of these broader readings that people have advanced over the years and explain what I think about them, which is generally that they're unfortunately not too convincing. The broadest possible reading that I've seen is some have argued that basically immigrants in general were not included. And you can get this a little bit by some comments made during the debates over these laws that you're talking about not owing allegiance to anybody else. And even a little bit in that original Civil Rights Act language where it says not subject to any foreign power. Michael Ramsey had a great law review article, and he's basically on, I basically agree with him. We're on the same side that birthright citizenship is required. But one of the things he concedes in that article is that most U.S. born children of aliens would be subject to a foreign power, at least in some certain limited sense, that their home countries might still consider them to be citizens or subjects. So that would be the case for this extremely broad reading. To me, the problem with it is that we have much more specific evidence from this time period and all points very clearly in the other direction. The 1866 Act was actually vetoed before the veto was overwritten. In his veto message, President Johnson explicitly said that the citizenship clause comprehends the Chinese of the Pacific states, talking about Chinese immigrants. He very explicitly says, one of the reasons I'm vetoing it is that it would make legal immigrants citizens. And in the debate over the ultimate amendment, Senator Conness made kind of a twofer comment where he says he's talking about the same thing, immigrants, the children of Chinese immigrants, and he says we've already declared by law basically that they're going to be citizens, and now we're proposing to incorporate the same thing into the Constitution. So to me the history there is just extremely clear that this was always intended to apply to immigrants in general. If you were an immigrant and you had a child here, you would receive birthright citizenship, and of course that was later confirmed in the Wong Kim Ark Supreme Court case. A slightly narrower read of this is that it can be used to exclude illegal immigrants, if not immigrants in general. And the really tricky thing about that is that not only were they not thinking about immigration all that much when they wrote the 14th Amendment, but illegal immigration wasn't even a thing. There were basically no limits on immigration to the U.S. We were trying to populate, a country that was sparsely populated. So what you have to do to make this case is you need to look at the populations that they specifically discussed, the people that they didn't want birthright citizenship to apply to, and see how analogous they are to illegal immigrants. And that gets very tricky. Probably the biggest point of contention here was the treatment of Native Americans. They wanted to make sure that Native Americans who lived among their tribes and were treated as something of foreign countries were not considered U.S. citizens. And there's during the debates over the amendment, Senator Lyman Trumbull makes the following comment, which is one of the most direct, kind of statements of what they meant by subject to the jurisdiction. And he said, quote, "That means subject to the complete jurisdiction thereof. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. Can you sue a Navajo Indian in court? Are they in any sense subject to the complete jurisdiction of the U.S.? By no means. We make treaties with them, and therefore they're not subject to our jurisdiction. If they were, we would not make treaties with them. And he goes on to say, also, if you want to sue a Navajo Indian in court, you can't just sue them in a court. And you can't just pass a law to control them. You have to sign a treaty. So there's a few things that I find really interesting about this quote. One is it's frustrating because he's admitting that the language is a little unclear, and he feels the need to add in this other word, subject to the complete jurisdiction. You just want to grab him and shake him and say, like, dude, make it clearer. If you need to add language to this to explain to us what it means, why don't we make that clearer? And then he's also got this comment about not owing allegiance to anybody else, which is a little bit vague. Maybe you could kind of say that if you're illegally in the country, maybe they don't owe us the same allegiance, and so owe some allegiance to their home country. But then he goes through these tests, which is, do we make treaties with them? We don't make treaties with illegal immigrants. You can sue illegal immigrants in court. They're subject to our jurisdiction in all of those senses that he specifically added. And the other categories that were frequently discussed at this time are also, frankly, not that helpful. One is invading armies. On the one hand, invading armies are there without our consent, so you can kind of say they're like illegal immigrants like that. But I think an invading army is out of our control in a very different way than an illegal immigrant is. And the final one is, of course, diplomats, who have this sort of legal fiction where they're in the United States, but they're not really subject to our laws. They have diplomatic immunity. So all of these groups that they're talking about are outside the authority of the U.S. in a way that illegal immigrants are not. And I think it's a bit of a stretch to kind of lump them into that same bin without clearer evidence than that, and especially now that we have so much precedent at this point of doing it a different way. So again, if you were to time travel back then and said, hey, we passed these immigration laws and people are coming into the country illegally, and then the instant they have a child here, the child's instantly considered a U.S. citizen, and we even have some people who are coming in just to have a child and then leave again, known as birth tourism. They might agree, wow, that's pretty bad. But I think they might also agree that they needed to rephrase the law a bit to make it clear that that's not allowed. I don't think that the language that they wrote does that. So the final and most narrow reading of this that I wanted to give some attention to, because it's one I'm somewhat sympathetic to, is the idea that the 14th Amendment has something of a domicile or residency requirement. This is something that's a fairly new development in the argument over this. There's an article by Andrew Hyman just this year making this case. It's touched on a little bit by Amy Swearer in her 2020 law review article. And then there's a 2015 article by Justin Lallman that I highly recommend because it's a really good summary of this view. But domicile is basically a legal term. And it's essentially where you would call home. It's somewhere that you have a permanent residence and you don't have any plans to relocate. It's where you live on a kind of a somewhat permanent basis. And the big policy advantage to me of drawing the line this way is that it really targets the most egregious situations where people are taking advantage of us to deliberately come and have a child and then leave just so that child gets citizenship, which I think most people would agree is the most egregious thing. It's not; these are not people who are even sneaking into the country to set up a life here because they want to live here and want to be Americans. This is just taking advantage of this sort of loophole in our law. And the reason I find it kind of interesting legally is that you can at least piece together some evidence from multiple points in time that this view was at least in circulation back at the time that this was all being debated. So in the debate over the 1866 Act, there's an Iowa representative named James Wilson made a comment about the way that we treated citizenship and the way we should treat citizenship, said every person born in the U.S. is a natural born citizen of such states, except it may be that children born on our soil to temporary sojourners or representatives of foreign governments. Senator Trumbull made somewhat similar comments. He talked about how he was thinking about how to word the act and thought about using the term allegiance to do it. He rejected that idea because there's out of a concern that there's a certain allegiance owed to even temporary visitors, even to foreign diplomats, because they're here, they need to be respectful of us. But he said that, quote, it was found that a sort of allegiance was due to the country from persons temporarily resident in it, whom we would have no right to make citizens. I think if you read that quote, it's a little unclear if he's just talking about diplomats or is talking about temporary visitors as well. But when he wrote a letter to President Johnson over the 1866 Act, he actually used the word domicile. The bill declares all persons born of parents domiciled in the U.S. to be citizens. Another little piece of evidence you can kind of allude to here is the text of the 14th Amendment itself. It says people are citizens of the United States and of the state wherein they reside. I don't think that quite counts as restrictive language that says you have to be a resident of a state to get the national citizenship, but it kind of alludes a little bit to like a background assumption that somebody getting this would likely be a resident of a state. And the Justin Lalman article from 2015 that I referred to earlier does a really good job of going through the subsequent history as well. And this is where the evidence gets pretty divided. There's a handful of court cases that weighed in on it. They're a little divided on it. There was a congressional bill proposed that would have clarified some citizenship matters. It ended up failing owing to unrelated things, but it was put together by a large committee, and it would have taken the view that temporary visitors would not get citizenship for their kids. But there was an objection to the bill that was a change to our laws. And it kind of goes the whole way this way. You can point to a few little pieces of evidence here and there at every point in time, and yet there's always somebody on the other side of the ledger as well. So it's not an overwhelming case, I don't think, that this was intended to exclude temporary visitors. But I think the case is certainly much stronger here than it is for the other bigger categories we talked about. And lastly, there's this decision of Wong Kim Ark, which is really interesting on the domicile front as well. It's interesting because Ark himself his parents were domiciled here when they had him. It was not actually an issue in the case, but both the majority opinion and the dissent made repeated references to domicile. Both when they discuss the question that they're resolving and when they ultimately resolve it, the majority notes that he was domiciled here, though they also refer to British law about citizenship and note that the British law did not require domicile for someone to have birthright citizenship. And then the dissent takes the opposite view and says that, well, the British may have done it that way, but the United States certainly has different views about whether you owe undying allegiance to the king because you were born on British territory, and takes the opposite view. So I think that there's a much more mixed record, and I think I'm much more sympathetic to that narrow reading that the birthright citizenship does not apply to people who were just temporarily visiting here and had no intention of making this their home. I also think that's a fair way of doing it, but I don't think that's a knockdown argument that's guaranteed to win in court. So to kind of sum up all my views on this, I would not create the system that we have today, but I think that for the most part, the Constitution requires it. And most sympathetic of all these arguments to the domicile residency requirement. But I we'll look forward to seeing what John Roberts and Brett Kavanaugh make of it, because theirs is the opinion that really counts. So thanks again for having me, and I'm eager to hear what Ilya has to say about all this.
Thank you. Professor Somin.
So thank you to the Society for Rule of Law for organizing this event, Robert for his thoughtful presentation, and all of you for listening. I'm going to start by talking about the legal issue, although to a large extent I agree with much of what Robert has said. Then I'll talk about sort of the moral and policy issue where I think we differ somewhat more. My general view is that it's very obvious that birthright citizenship for children of undocumented immigrants and also those who are here temporarily, yes, even including the relatively rare cases of birth tourism, that that is pretty clearly guaranteed. The opposing arguments are weak, and many of them have the implication that if you buy them, the citizenship clause would not even achieve the goal of giving citizenship to children of former slaves, or making the former slaves themselves citizens, and that's an additional reason to reject it. On the moral and policy issue, I think birthright citizenship is not the optimal system, but it's better than more restrictive options, which is what we realistically would get, at least at this point in history, if we somehow were to get rid of it. So I'll first start out by looking at what the Trump executive order actually does. And it's important to recognize that it is not actually limited to denying birthright citizenship to children of undocumented immigrants. It also denies it even to children of those who are in the United States on any kind of temporary visa, even an employment visa to potentially last years. So there would be hundreds of thousands of children every year who would be denied citizenship as a result of this, and babies would be subject to deportation. The constitutional text on this is also actually very clear. As Robert mentioned, the text of the 14th Amendment grants citizenship to all those born in the United States, and, quote, subject to the jurisdiction thereof. And the goal of this was the main goal was to overturn Dred Scott, which had said that blacks, even those born in the United States, could not possibly be citizens. And here the idea is any who were born in the United States, including those born as slaves, would be citizens. And the natural and relatively obvious reading of subject to the jurisdiction thereof is simply that they're subject to U.S. laws. So, for instance, if they commit a crime, they can be prosecuted for that. If they commit a civil wrong, like a tort or breach of contract or the like, they can be sued in U.S. courts over that, and so forth. That's what subject to jurisdiction thereof means, and does the only people who are excluded are people who are not, in fact, subject to U.S. laws. And that's precisely what the Supreme Court ruled in United States versus Juan Kim-Ark in 1898, where it said that it applies to all children born in the United States except those who are, quote, children of foreign sovereigns or their ministers, or on foreign public ships, or enemies within and during a hostile occupation of our territory, and with the single additional exception of children of members of the Indian tribes owing their direct allegiance to their several tribes. What all of those categories of people have in common is that they're in fact exempt, or at least at the time were exempt from most U.S. laws. This is obvious for those who have diplomatic immunity with members of invading armies. They obviously, if they had control of territory, and obviously U.S. jurisdiction didn't run there, at least for so long as the invading army was present. And with the Indian tribes, there's a long and complex history, but basically then, and to some extent now, there were some territories ruled by Indian tribes where U.S. law, to a large extent, didn't apply because the Indian tribes had some degree of independent sovereignty of their own. That loophole has largely been closed by a 1924 law, which did in fact grant citizenship to all members of Indian tribes born in the U.S., but the special sovereign status of Indian tribes explains that exception. There are various counterarguments, some of which Robert has mentioned. One is the idea that jurisdiction means, quote, complete political jurisdiction. This argument, and therefore it only applies to people whose parents have the full right of citizens, like rights to vote, right to serve in the armed forces and hold public office, and so forth. Obviously, the amendment doesn't say that. Moreover, if it did say it, it would have allowed the exclusion of African Americans. States or the federal government could simply have said, well, blacks don't have the right to vote. The 14th Amendment did not actually grant the right to vote. That had to wait for the 15th Amendment, which was enacted years later. And so they could simply have said, as many states and the federal government did say in the pre-Civil War period, that blacks, even free blacks, are not allowed to serve in the militia, not allowed to vote, and have other severe restrictions on their citizenship rights. So this argument would defeat the main purpose of the 14th Amendment, and I think there's a good reason to reject it for that reason. Then there is the domicile argument, which Robert did a good job of canvassing. I would simply say that there are zero references to domiciles in the 14th Amendment itself. If having a domicile was required, they could have put it in. And as he noted, the idea of domiciles was certainly discussed at the time. So the exclusion of that term, I think, is meaningful. To the extent that it does matter, certainly undocumented immigrants and others who live in the United States for a long period of time, like those on temporary visas, very clearly are domiciled in the U.S. I would argue that for the time that they're giving birth, even quote unquote birthright tourists are domiciled in the US in a sense that they're clearly living here. But that's a pretty narrow category of cases, but probably less than 1% of all people covered by this executive order. It is also sometimes argued that the issue of illegal migration simply wasn't covered by Section 1 because there wasn't any illegal migration at the time. That, frankly, just simply isn't true. There was, in fact, a large class of people who either they or their parents had entered the U.S. illegally who were covered by the 14th Amendment, and that is slaves who had been brought in illegally after the abolition of the slave trade, after the federal government banned the slave trade in 1808. But nonetheless, there was a lot of illegal slave trading going on, and a substantial number of freed slaves were either descendants of those who had been brought in this way or themselves had been brought in this way. Moreover, even though the federal government had very little in the way of immigration restrictions, some state governments did, so there were illegal migrants as a result of that. I would add also that there was a big ongoing debate about migration restrictions. At the time, there was already a large movement to restrict Chinese migration, which culminated just a few years later in laws like the Page Act and the Chinese Exclusion Act. So the issue of illegal migration and potentially illegal migration was certainly out there. If they had wanted to exclude children of illegal migrants, they could have done so, and they pretty clearly did not. Finally, there's an argument that Robert didn't mention, perhaps because it's just a really bad argument, but there's the argument that illegal migration qualifies as invasion, and therefore, illegal migrants are analogous to members of invading armies. And I think this is pretty obviously not true. As James Madison said in discussing the invasion provision of the Constitution, an invasion is an operation of war. It requires some sort of organized armed attack. That does happen when there is an actual invading army on our territory, as for instance during the War of 1812, the British soldiers who burned Washington, D.C. or whatnot during that war were a genuine invading army. People illegally crossing, seeking freedom, opportunity, and the like, whatever else you think of them, they don't qualify as invaders. And if you say that they do, that has drastic implications of other kinds, such as that the federal government could suspend the writ of habeas corpus and detain people, including even American citizens, without trial anytime there is any significant illegal migration, which in modern times is pretty much all the time. So in the last few minutes that I have, I'll talk briefly about the moral and policy issues. I think abolishing birthright citizenship would have drastic and harmful consequences in that it would make hundreds of thousands or potentially millions of people subject to deportation who otherwise would not be. Those people would suffer enormously, many of them. In many cases, a lifetime of poverty and oppression would face them. The U.S. economy would also suffer because of their absence, would cause great harm. Tax revenue would also decline and so on. So doing this would be unjust and also harmful to the U.S. economy. I do think, however, that birthright citizenship is not the optimal policy in that I think there is something deeply unjust when people's rights and liberties are dependent on arbitrary circumstances of birth. In this case, who their parents are or where they were born. Recall the whole reason why the 14th Amendment sought to ban racial and ethnic discrimination because race and ethnicity are themselves arbitrary circumstances of birth. That whether you're born to a black parent or a white one or an Asian one or whatnot, it's not something you can control. It's not something that determines how good a person you are, and it's certainly not something that determines how much freedom you should be allowed to have. Whether your parents are U.S. citizens or whether you were born in the United States is a similar morally arbitrary circumstance. You can't control it. It doesn't determine how good a person you are, and it should not determine what rights and liberties you have. So the better policy, one laid out by George Washington, is as he said, that the U.S. should be a, quote, asylum for the poor and oppressed of all nations and religions. Other founding fathers said similar things, James Madison, Thomas Jefferson, others. We should replace the presumption of exclusion that currently exists with a presumption of openness, that people should be allowed to live and work where they want, regardless of who their parents are, where they were born, unless there's some compelling reason to stop them. Like if there's evidence that they, are migrating for a purpose of committing acts of terrorism or espionage or the like, in which circumstance we could stop a native-born citizen as well if we find that, that they're doing that, then issues of other kinds of rights of citizenship can be determined in other ways, like we have qualifications for voting and the like. Uh, um, so, but in the absence of such a policy, which certainly is not going to be enacted anytime soon, birthright citizenship is far superior to the alternative of simply excluding people and making them subject to deportation just because they were born to the wrong kinds of parents. There are obviously other moral and policy issues related to this. I cannot cover them in the time that I have left, but I do cover them in much more detail in my book, Free to Move, and in other writings. And on that, I conclude, but I would be happy to discuss further in response time and questions.
That was fantastic. Ilya, thank you. I'd like you each to just spend 2 or 3 minutes responding to each other if there were points you wanted to clarify or return to. Robert, how do you respond to the full libertarian argument?
Well, I mean, as Ilya said, I think we agree on a whole lot of stuff here. We mainly agree on um, the legal aspect of things. I'm a little more open to seeing the domicile and residency stuff tested in court, but as I said, that's a fairly weakly held view. On as to the open borders versus controlled borders debate, that wider thing, I don't think we're going to resolve that here. I do understand the point that it's unfortunate that where you're born is not something that you had any control over. It can greatly affect where and when you were born. Greatly affects how you turn out and how the opportunities that are available to you. It's just sort of one of the great injustices of life. I don't know that given human nature being what it is, I'm not sure that extremely loose immigration policy is necessarily a good solution to that. I think there's a lot of frictions and a lot of resistance and backlash that you engender when you have overly loose immigration policy. And as I said, we can definitely debate exactly what the number should be. I'm not saying that exactly the number we have now and exactly the mix we have now is the correct one. I just think that there do need to be limits, and if we're going to have limits, we need to enforce them. And I maintain that it's insane to say that we have limits on immigration, but if you come here in violation of those limits, we will give you instant constitutional right to birthright citizenship. So I guess I'll leave it at that.
Yeah, so obviously there are broader points here that we're not going to resolve in these few minutes. I would just make sort of a couple additional points. It is true to some extent that immigration restrictions may be rooted in human nature, though for much of our history we didn't have them. But a lot of evils are rooted in human nature. Violence is rooted in human nature. For centuries, people thought that the domination of women by men was rooted in human nature, and maybe it is to some degree. That doesn't mean that we can't get rid of these evils. There are many long-standing historical injustices, including the slavery that we thought to abolish in the 13th and 14th Amendments, that also arguably had strong roots in human nature, but yet we got rid of them because we found that even though they had some roots in human nature, they're still deeply unjust. And here you can argue to some extent it's the fact that circumstance of birth determine your prospects is, you can say that that's just an aspect of the nature of the world. But here it's reinforced by government coercion, as in if you're born in the wrong place and then try to move somewhere else, the government will physically force you to be removed, even though we can't get rid of all sort of unearned inequalities or whatnot, and it might be dangerous to try. We can certainly not reinforce them through government coercion. That's something that we can achieve, even if we can't achieve some kind of state of perfect justice. Finally, on the birth tourism and domiciles. Yes, obviously, not only can it be tested in court, it already has been tested in court, rejected by a couple of judges. But again, I am less troubled by birth tourism in that if birth tourism is a way to circumvent a law which is fundamentally unjust, then by all means, let it be done. And also again, it's a relatively small phenomenon in any case. But there are many situations where laws have various exceptions and loopholes, and whether we view those loopholes negatively or positively depends to some extent on how you view the underlying rule to begin with. If the loophole is a loophole from something that is fundamentally evil and unjust, then by all means let people use the loophole. In any case, this relatively rare set of cases, should not be the tail that wags this much bigger dog. And on that note, I think we should take questions from the audience.
Thank you. We got a bunch of good questions. But before I start with them, I want to ask you all one question, which is you both have sort of different instincts on pretty pretty dramatically different instincts on some of the underlying policy issues, but both think the law is pretty clear here. That the Constitution's clear, any fair reading of it's clear, as close to clear as you can get, and that the outcome in the courts of is pretty predictable. Nonetheless, you have a new president coming out with an executive order like this. I mean, what are we to think of that about a president is issuing an executive order that is so likely unlawful and to be found so by the courts? Is that kind of a proper presidential gambit, or is it in tension with his role to take care?
So I think he's doing a lot of illegal things on a lot of fronts, and he has shown throughout his career that he has no respect for the rule of law. So therefore, it is improper. I do think there are cases where laws have unclear margins and the like, and presidents can potentially issue orders which things are maybe unclear whether some parts of the order are illegal or not. But with this and a bunch of other things that he has done, he has crossed far beyond those kinds of boundaries. And it remains to be seen not just what the judiciary will decide on various issues, but whether he will obey those decisions, as they've been making noises that they might not.
Yeah, I mean, I think the president does have some role in if his opinion of the law differs from that of the judicial branch to push that and see what ruling you can get. I think we're in pretty broad agreement on what the law actually says here. I think this goes a little beyond that. It's a little outside of that. But I mean, this is how things go under every president. There's new executive orders, and they get sued in court, and there are rulings about what he did, whether it was legal, and then the next president comes along and undoes all of them. So. We just run the treadmill.
One of the questions I have here is kind of related. One of our first questions was that this birthright citizenship is not just in the Constitution; it's also in the U.S. Code, right? It's in law passed by Congress. So, if one did want to change this policy, shouldn't one start there, not by executive order?
I do agree, though. The wording of that federal law is almost identical to the 14th Amendment. So there's an argument, well, if the one doesn't include undocumented immigrants or people on temporary visas or the like, then the other doesn't either. However, it's worth noting that at the time that this law was enacted, I think in the 1940s, if I remember correctly, it was generally assumed that undocumented immigrants and others on temporary visas and so forth were actually protected. And therefore, you can argue that even if the 14th Amendment is reinterpreted not to cover such people, that the statute still would, but the two do have identical wording, so there is an argument that they should be interpreted the same way. It would be a little bit strange if a statute that had the same wording as the Constitution was interpreted differently, though such things are not completely unknown.
Yeah, I would just add that Andrew McCarthy had a National Review piece about this a while back, where he pointed out it kind of broadens the inquiry a little bit. You're not just looking at the the meaning of the 14th Amendment. Now you're also looking at what the Congress meant when it passed the same exact words later. But yeah, the fact that they're the same exact words to me suggests that interpreting them differently is kind of a stretch. But yeah, depending on what kind of originalist you are, you might be able to make the case for considering slightly different evidence for the meanings of both of them.
Another question we have, a scenario, Ilya, that you raised just a moment ago was, so what does happen if the courts ruled the executive order is unconstitutional. Birthright citizenship is guaranteed by the Constitution, but the president refuses to acknowledge that ruling and continues to refuse to issue passports or other documents to children born here, not of citizen parents.
So nothing good, and this is an issue that goes far beyond this particular executive order. That at that point, it's a question of whether there will be enough of a backlash in the political system, the legal system, and elsewhere to compel him to obey court decisions. If in fact he refuses to obey them and gets away with it, that's a major step towards dictatorship. And that is an issue that goes far beyond this particular order. It's already cropping up in litigation over other illegal things that he has done, such as trying to usurp the spending power from Congress by not allocating grants as the law requires. So I have a great fear about this issue, in that ultimately, as many have said, courts don't have their own army. They don't have even much in the way of their own police force. Their decisions are respected because other institutions of government follow them, and there's a strong norm of doing so, that for the most part held even through most of the first Trump administration. If in this administration they're not going to do that, that is a major constitutional crisis, and one that goes far beyond the specific issue of birthright citizenship.
Question about separation of powers, Robert, and it's just that if the Constitution gives Congress the power to establish rules for immigration naturalization, why do we have presidents kind of purporting to be so active here, whether it's in this or various emergency declarations? How do we think about this from a separation of powers perspective? What's the president's proper role in immigration policy more broadly?
Yeah, I mean, the Constitution sets a floor for citizenship, not a ceiling, and then Congress can use its naturalization power to make citizens of people. It's not forced to, is basically the way it works. But the president is the one who interprets and executes the laws, and what he's saying is that both the laws in the statute books and the text of the Constitution don't require me to do what previous presidents have done, so I'm going to do it differently, he said. But he's basically saying there's gray area and wiggle room in here that he is able to exploit when he's enforcing the laws and executing the laws. So certainly if Congress wanted to pass a law explicitly saying illegal immigrants are citizens, that would be something that would be within their power to do clearly, and would put this to rest. But we don't have a Congress who is probably going to do that anytime soon.
Yeah, so to the extent that there is an immigration power in the federal Constitution, it is a congressional power. However, Congress has enacted various statutes that delegate some authority to the president. Some of those, I would argue, actually are excessive under non-delegation and other principles, but that hasn't been tested much in court. Also, and so the president can claim a lot of delegated power. And under this president, he's also claiming inherent power under the invasion clause, which I mentioned earlier. I think that claim is badly wrong, and very dangerous. But he is making that claim. Ironically, other than naturalization, which is not a power over immigration, it's a power over grants of citizenship. There is no actual immigration power listed in the Constitution. And for the first century of American history, the dominant view expressed by James Madison and Thomas Jefferson, among others, was that the federal government did not actually have a general power over immigration, at least peacetime immigration, and rather those powers were primarily in the hands of the states. Not until the Chinese exclusion case of 1889 did the Supreme Court rule otherwise, I think in a pretty weakly written opinion, but that obviously decision is still on the books. To the extent that there is power over immigration other than naturalization, the Constitution's text doesn't actually clearly settle where it lies. However, the Chinese exclusion case does suggest that it lies in the hands of Congress, and certainly the naturalization power, which is what's at stake in the birthright citizenship debate, is clearly allocated to Congress because it's in the list of congressional powers. But in this area of immigration, like in some other areas, but even more than in other areas, presidents over time have managed to seize a lot of power. But the powers that Trump is asserting go beyond even what previous presidents have done. Like he essentially asserts the power to completely shut down virtually all legal immigration using the so-called invasion clauses of the Constitution. So there is a long history of executive power grabs by presidents of both parties, but strikingly, this president, in just the first few weeks of his term, has asserted even broader power to do things like that than than others have in the past.
This is a good question for a law professor. Is there any current relevance to the long discussion of common law in Wam Kim Ark? I admit that I
Yeah,
read the decision and skimmed it myself.
yeah,
So
so that's a good question. Um, I think when Juan Kim Ark is a precedent, I think the most important part is that the discussion of the meaning of under the jurisdiction thereof and the 14th Amendment, which is not required to follow the British common law. However, it is important to note, as the court does, that under the British common law, which in some respects was a model for the US, I stress the word some, which is doing a lot of work here, that people born to foreign citizens in the United Kingdom were generally granted British citizenship, except those of born to diplomats and the like. So to the extent the British precedent matters, centuries of it also worked in the way that Juan Kim Ark says, though I don't think that British common law precedent is essential. You might say if the USS was based on British common law, why did we need the citizenship clause in the first place? The answer is, of course, that the Dred Scott case had basically said that there is a giant hole in those common law principles for blacks, famously ruling that the blacks, even free blacks, could never be citizens of the United States. And the British common law, although certainly Britain was not free of racism, it did not make those kinds of racial distinctions. Though you could argue, one reason why not is because at that time there were very few non-white people in Britain. I think there is some relevance to that discussion of British common law to the extent that you think that British common law is sort of a model for the birthright citizenship system. But ultimately, to my mind, the text of the Constitution is what matters, and Juan Kim Ark's interpretation of that, I think matters more than the other discussion.
and um, how do you have a feeling for this is a very soft question, but uh, how how does the how would, in your mind, the abolition of birthright citizenship sort of change how we think of citizenship in this country, what it means to be an American? Feel free to dodge that question if it's too loose for either of you. But I think we there's a lot of, I guess, warm rhetoric out there from people like Ronald Reagan about how, people become American here, and it doesn't matter what your family history is. You could be a third generation German, but if you come from the wrong family line or the wrong circumstances, you're not really a German, but you are in America. Does that hold at any kind of moral or force with either of you, or?
Yeah.
I mean, I would say that it depends. What do you mean by doing away with birthright citizenship? If we're talking about these narrow exclusions where we're going to exclude birth tourists or even illegal immigrants, I don't think that does that much damage to it. You're just saying that if you want to be part of our country, you have to come here legally. If you were to go, full, whole hog, nobody's a citizen unless they have the blood citizenship by being born to parents who are citizens. That would be a fundamental change in what we think it takes to be an American. And I don't support that. When I say I'm skeptical of birthright citizenship, I'm talking about the more narrow exclusions that people have been talking about.
So obviously it's a broad question. It's hard to know for sure, but what I would say is this is part of a general trend on the political right to be towards a much more exclusionary immigration policy, and which is at odds not only with things that Reagan said, but with things said by the founding fathers and others, and also in many quarters of the right that the idea that we should only accept people who come from similar backgrounds and cultures and the like, as you can make the only kind of immigrants the current administration seems to want are South African Afrikaners who should get according to the executive order priority in refugee processing. It is moving towards an idea of sort of blood and soil concept of who should be allowed to be an American citizen, which is not only at odds with American tradition, but deeply harmful and dangerous. That's not to say that there aren't precedents like this. Obviously, I mentioned before the movement to exclude Chinese immigrants in the 19th century, later movements to exclude even most European immigrants, also often justified on sort of blood and soil kinds of arguments. So this is not completely new in American history. Nonetheless, it has been deeply harmful and unjust when it happened in the past. And to the extent that it's happening again now, it's a bad thing. And the attack on birthright citizenship is just one part of this sort of multifaceted effort to install this kind of set of ideas.
One of our viewers is objecting to our use, or maybe my use, of phrases like ending and banning birthright citizenship by this executive order. And she writes, "There's nothing in this order that says a word about banning or ending birthright citizenship. It only defines subject to jurisdiction thereof language." Does she have a point? Am I being too loose?
I mean, if you were putting it this way in a legal brief, she might have an objection. In ordinary parlance, I think there's not a problem. And what's clear is that it is banning birthright citizenship for a wide class of people, even if it's not banning it for everybody. I think everybody understands that that's what we're talking about. And in a discussion or a panel, we don't have to need to have the level of precision that we have in a legal brief.
Yeah, that goes back to the distinction I was making. It's a limitation to birthright citizenship, and to the way that we've historically done things. It does not end the practice of being born here makes you a citizen in general. It carves out exceptions to it.
Very large exceptions.
And do either of you have thoughts on whether the decision of Trump against the United States on immunity has any implications here, to the extent that it comments on executive authority and exclusive executive powers?
I think it's a bad decision, but it doesn't in of itself have any implications for this issue. It doesn't say that the president has a general right to disobey the law. It doesn't even say that he has complete immunity from criminal prosecution. Exactly what scope of criminal immunity he has is itself unclear under that decision. We can have a whole other panel on that. However, it may, even though legally speaking, it doesn't have implications, it may embolden him to take legally questionable steps. And that is one of a number of reasons why, I think that was, a bad decision when it came down, though the ultimate problem with it is it's an atextual decision because no such immunity is actually outlined in the Constitution.
Well, we are coming up on close to the hour. I'm not going to get to all the questions. We got a ton of questions today, so that's a credit to both of you. And the subject is obviously an important one that people care about. So thank you so much for doing this. We have a few minutes. If you all would have some closing thoughts you'd like to make, I'd love to hear them. Can we start with you, Ilya?
Sure. I mean, I said most of what I have to say. Legally speaking, I think this is not a close question. We've talked about the different arguments and why efforts to show otherwise not only are wrong, but if you were to accept them, many of them would have very dangerous implications, such as that even many blacks could not have citizenship, or that the president would have vast, sweeping, and dangerous powers under the Invasion Clause, and so on. Obviously, there's broader issues of morality and policy here over which we differ and which we're not going to likely to resolve in the next minute or two. I made some points about them earlier. I make more in my book, Free to Move, and other writings. And obviously, those issues, I think we're going to continue to be subject to debate. What I think should not be as much debated and disputed is that this order is deeply at odds with the Constitution as written. And courts should continue. 3 courts have already ruled against it. I expect others to do so in the future. And the administration has a constitutional duty to obey those rulings when they come down.
And I guess I'll just end this where I started it back in 2018, which is that, in my view, birthright citizenship is a nutty policy, but it's one that we're stuck with. I'm not a fan of, having immigration laws and then giving benefits to people who break them. But that's the 14th Amendment was not written with that in mind. It applies reasonably clearly to most of these situations, and we should follow the law. And I'm very interested to see what the courts make of it, because I don't have any actual authority to implement any of that. So thank you so much for having me.
Well, thank you both for your time and your insights, and thank you for putting up with my struggling voice today. And thanks to everyone in the audience. Just a reminder again, we are a membership organization. Your membership makes this kind of programming possible. Please consider signing up or encouraging your friends to do so. This event will be available on YouTube to watch probably later today. So come back to review it and share it broadly. Follow us on YouTube, Twitter, Blue Sky, and LinkedIn, where we will have lots more of announcements about upcoming webinars and in-person events. We have lots of work before us in the coming months, and look forward to sharing all that with you. So thank you all very much, and have a wonderful rest of the day. Thank you.